Hello and welcome to the screencast for the Chickasaw Nation Law Library's award class on citators. Participants will receive 1 point for watching the screencast and an additional point for completing the exercise at the end of the screencast. So what exactly are citators? Legal citation services, citators, let you know how and when a particular legal resource has been cited. It's really important because of the doctrine of precedent, which is the idea that similar fact patterns should result in similar legal outcomes. So we rely on judicial and statutory precedent to ensure those similar outcomes. According to Blacks, a citator is a cataloged list of cases, statutes, and other legal sources showing the subsequent history and current precedential value of those sources. Citators allow researchers to verify the authority of a precedent and to find additional sources relating to a given subject. So why would you need to use a citator? You need to use it for case verification. Can you still use the case as precedent? Is the case still good law? Citators also help figure out the history of the case, the treatment of the case, and can help locate additional primary and secondary sources. There are also ethical considerations. So here we have an example of Horatius v. Mazur, where it says count 2, which sounds an assault and battery, is not dismissed. In that respect, experienced counsel such as Mazur's should have known better than to cite Geis v. Phoenix Company of Chicago. And if they did not know better to begin with, they should have learned better by the simple act of shepherdizing Geis, as every lawyer should do before citing any case. That 1994 decision was expressly distinguished just 3 years later by another case. So let's go ahead and watch this O.J. Simpson clip. From our friends at Shepard's.
Unfounded allegations will change the truth.
Why don't you address the legal issue on motions to reconsider, counsel?
Yes, and I meant to start with that, Your Honor. I got sidetracked.
That would help.
There is no, I'm sorry. There is no legal provision for a motion for reconsideration in criminal law. That is only in civil law. It is recognized in Civil Code of Procedures, Section 1008, and what they require in civil law is that the party seeking reconsideration show newly discovered facts. In this case, we have no newly discovered facts with respect to the motion for reconsideration of Laura McKinney.
But doesn't the case law dealing with that particular code section include criminal cases? If you shepherdize that, you come up with some criminal cases.
We did. I believe that none were found, Your Honor. We don't have any in our motion, which leads me to believe that no, there aren't any criminal cases under that section. And you asked me that question because you knew Ms. Lewis wrote the motion, huh?
No.
But no, as far as I know, there are no criminal law cases that involve that section because it's not recognized in criminal law. So, I mean, at least in theory, we didn't have to have all the argument. But
So if my Pepperdine law clerks found some...
Did they? Criminal cases? And what do they say?
Say it's applicable to criminal law cases.
Okay. Nevertheless, we don't have any newly...
sanctions.
I'm sorry, Your Honor?
Never mind.
Okay.
There's a rule in the civil procedure that an unfounded motion for reconsideration is the subject of sanctions. Just an aside.
Just an aside. And many of you probably were not old enough to really recall the drama of the O.J. trial, but that was considered the trial of the century back in the day. So if you fail to actually shepherdize a case or use KeyCite or any of the other citators in law school, probably the worst that's going to happen is you'll get a lower grade. Out there in practice, you're going to get a dress down from the judge. And in Marcia Clark's case, not only did the judge chew her out, but millions and millions of people around the world actually saw that she and her team failed to properly shepherdize to make sure a case was still good law. So again, with the ethical consideration, there is a rule in the Oklahoma Rules of Professional Conduct which states a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So some basic terms. If it references a cited case, that is your case. That's the case you're looking at. Citing cases are cases that refer to your case. History describes what has happened to a cited case, and a treatment tells you how the courts have treated that particular case. How have they dealt with that case? Just a quick note on shepherds in print. It's almost never used now. But here are some basics just in case you ever have someone tell you that you need to shepherdize using the books. You would choose your jurisdiction, choose the latest supplement, check the cover, and there are no pocket parts. You would need to get every volume with your case. We do not update shepherds in print any longer. So we actually have had some attorneys fairly recently either come in and want to shepherdize using the books because that's what they were taught, or they have sent their summer associates in to go ahead and shepherdize using the books, and you just simply can't do that. It's basically considered malpractice right now because it's not going to have the most current up-to-date version even if you were to use the print. So keep that in mind. You would need to shepherdize using Lexis or KeyCite using Westlaw Next. And again, just some more details on how to use shepherds in print. You'd start with the earliest volume, look up the volume number and then the page number, and then interpret the information about your case and then repeat. It's a really long, drawn-out, fairly complicated process. On Lexis Advance, however, you can just type in shep : to go ahead and shepherdize. So here we've typed in shep : 286 Federal 2nd 327. And then when we pull that up, we've got McCollar v. Euler. So you can see there are 5 citing decisions. 4 are from the 10th Circuit, and 1 is from a New Mexico State Court. And remember that citing decisions are cases that cite to your case. Just a note about the Lexis signals and what they mean. The red stop sign means negative treatment is indicated, so that's a warning. This does not necessarily mean the case is no longer good law. The Q means questioned, so the validity or precedential value needs to be examined. The yellow triangle means caution, possible negative treatment is indicated. It may be limited in scope or criticized by other courts. There's also the table of authorities. These are the cases that your case relied upon when it was being decided. With shepherds, you can also set up a shepherd's alert to let you know if there's been any activity on a particular case. So that's kind of the basic nuts and bolts of Lexis Advance and shepardizing. Westlaw Next has their own version of Citator, which is called KeyCite. And here we do have the some explanation on what some of the symbols mean. So yellow flag indicates a document has some negative treatment. A red flag indicates a document is no longer good law for at least one point of law. And a blue stripe flag indicates a document has been appealed to the U.S. Courts of Appeal or the Supreme Court. And just some more information. A blue H just means that a case or administrative decision has some history. A green C means that it has citing references. And KeyCite also has depth of treatment stars, so that'll tell you like to what extent that particular case was discussed. So here I pulled up Miranda v. Arizona. At the top you can see there are tabs for filings, negative treatment, history, citing references, as well as a table of authorities. So let's take a look at the negative direct history. So we take a look at this. It's showing that Miranda v. Arizona was superseded by statute as stated in U.S. v. Dickerson. So this is the most negative. And you may say, well, I'm pretty sure that Miranda v. Arizona is still good law because I still hear police on TV shows talking about the Miranda warning. And that's why this is important. You can see U.S. v. Dickerson held that it was superseded by statute. However, if you KeyCite U.S. v. Dickerson, it's going to show that this was overruled by the Supreme Court. So that's why you always need to look at the cases to see exactly why it may have a yellow flag or a red flag and not just take it on its word. You're going to want to see exactly what's going on with that. So there is no real shortcut. You are still going to have to read those cases. And here we have a graph of the history of Miranda. You can see it's pretty complicated. A lot of activity going on. But for people who are really visual, it can help just so they can see the relationship between the final outcome and all the cases that happened before that. Citing references. This is showing an overview of everything, cases, secondary sources, etc., that cites to Miranda v. Arizona. And then if you wanted to set up a KeyCite alert, you just click on that bell icon. And basically what those alerts do is if there's been any activity on your particular case, you'll get an email or notification from Westlaw. That's how the Lexis notifications work as well for shepherds. So some tips: red flags and stop signs do not mean a case cannot be cited. It could be that you might be citing it for a particular part of the law that it's still good for the point you're using it for. It's been overruled for another issue. And that point of law that's been overruled may not be pertinent in terms of your particular argument. Keep in mind also, a lack of warnings does not necessarily mean that a case is still good law. So what we try to do is use the table of authorities to help overcome that particular issue. And I'm not going to go into extreme detail on this. This is a case where the Mincy case relied on an earlier case, which is in his table of authorities. That earlier case was overruled by a much later case, but somehow things got lost in the translation because they never talked about the Mincy case. They only talked about the earlier case. But you want to check that. This can be really useful, especially if you find a case that seems directly on point but no one has cited to it in a long time. That could be a clue that, like, okay, even though this case looks like it would be directly on point for making my argument, maybe I need to take a closer look and see why no one has cited to it. So that's what I would check into. So words of caution, you do have an ethical responsibility to make sure you're using sources that are still good law. And keep in mind that editors can sometimes make mistakes, so it's a good idea to check out both services if possible. We also have Bloomberg. So with Bloomberg Law, they have a citator called bcite. And here you can see what Miranda v. Arizona looks like. Over to the right, you can see the bcite analysis showing 44,137 positive references, 599 distinguished, 1 criticized, and 4 superseded by statute. Now you can see the direct history of the case from start to finish. This next tab is case analysis, where you can further filter the cases by positive treatment, distinguished, criticized, superseded by statute, as well as the citation frequency. And then next we have the Table of Authorities tab that lists the cases cited by your case. And then finally we have the citing documents. OSCN also has a citator feature called the Citationizer. So here's an example of the Citationizer. They have a summary of documents that cite the document. So these are all documents that cite to your document, and then Table of Authority is going to have the cases that your case relied on when it was being decided. Fastcase has its own citator as well called Authority Check. There's also an interactive timeline on Fastcase, as well as a citation summary listing cases. You can also filter by jurisdiction. Fastcase also has a feature called Foresight. And the way Foresight works is it identifies additional cases that may be relevant but may not contain all of your search terms. So this will be cases that the algorithm in Fastcase has identified as being helpful. And actually in this example, we've done Miranda v. Arizona. We actually did Miranda warning. And if you type in Miranda warning in your search, Miranda v. Arizona is not one of the cases that pulls up, because the court in Miranda v. Arizona didn't actually use the term Miranda warning. It was every case after that. But Foresight will identify Miranda v. Arizona as a case that may be pertinent for your research. And then Hein Online has a feature called Scholar Check. And Scholar Check shows other publications that have cited to an article in a law review. Again, this is a great way to find other sources that may lead you to additional primary authority. There's also Google Scholar. Google Scholar has a citator feature which shows other sources that have cited to your source. So we have some examples here. You can see cited by, like for this one, for example, cited by 73. There are some related articles. It just gives you a lot of really good information. So there is a Cali lesson on legal research if you wanted to review any of the materials. If you're just not quite sure how this all works as far as citators, there's that. There is an exercise on TWEN that must be completed in order to receive credit for watching the video as well as completion of the exercise. It's labeled as Using Citators 2015. If you have any questions, please let me know. Thank you.